The law recognizes that certain confidential relationships are important, and it protects statements made within those relationships. A parishioner confessing to a priest, a client confiding in a lawyer, or a patient revealing embarrassing personal information to a doctor. All may count on their confidential information remaining confidential. But, as with most legal principles, confidentiality isn't absolute. The California Supreme Court considered the relationship between doctor-patient confidentiality and tort law's duty requirement in Tarasoff versus Regents of the University of California. Tatiana Tarasoff attended the University of California with a man named Prosenjit Padar. They met in September 1967 and began dating. But by New Year's Eve, it became clear that Padar was far more serious about their relationship than Tatiana was. Tatiana told him she was dating other men and wasn't going to become intimate or exclusive with Padar. Padar didn't take the rejection well. He became severely depressed and eventually began therapy sessions with Dr. Lawrence Moore, a university hospital psychologist. In August 1969, Padar told Dr. Moore that he was going to kill Tatiana. Dr. Moore determined that Padar should be involuntarily committed to a mental hospital. He asked university police to take Padar into custody. However, when the officers picked him up, they decided that he appeared rational. Padar promised the officers he'd stay away from Tatiana, and they released him. Thereafter, Dr. Moore's supervisor, Dr. Harvey Powelson, directed him to cease trying to confine Padar. In October, Padar went to Tatiana's home. There, he stabbed her to death. Tatiana's parents sued the university, claiming that Dr. Moore owed Tatiana or her parents a duty to warn them that Padar was a danger. The Alameda County Superior Court dismissed the Tarasoffs' complaint. The California Court of Appeal affirmed, and the Tarasoffs appealed to the California Supreme Court.
It's undeniable that the Tarasoff case has been one of the most notable cases in the mental health world, and seemingly more so because of the civil aspects of the case and not really the criminal aspect, although it was very essential as well. But the civil aspects of the case is what kind of made it notorious. According to 3.04, Avoiding Harm, it mandates that mental health professionals, clinicians, psychologists, psychotherapists are mandated to make reasonable efforts to avoid harm with whom they interact with in an educational setting, a scientific setting, professional setting. And it's very needed that they make these reasonable efforts to eliminate harm where it is foreseeable and unavoidable. Now, granted, a lot of times it may not always be unethical and unavoidable. There might be an instance where a clinician may have to disclose confidential information in order to protect the welfare of a third party. Now, in relation to the Tarasoff case, the perpetrator and the patient was actually Mr. Padar, and the third party victim was Miss Tarasoff. And this unfortunate event led to Mr. Padar brutally killing Miss Tarasoff because his inability to accept rejection and impulsiveness. Padar, in fact, relayed his violent thoughts to his roommate, who was surprisingly enough Miss Tarasoff's brother, and his psychiatrist, and then his psychotherapist, at least 8 weeks prior to actually carrying out his motive. Now, it seems as though the clinicians involved were trying to avoid harm by not disclosing his thoughts for as long as they can until they actually were concerned about his intent, his obsessiveness of violent thoughts to hurt and control Miss Tarasoff. Now, eventually, his psychotherapist consulted his supervisor, and then they agreed to send a letter to the University of California, which was Mr. Padar's graduate school, to inform them of his intent. Now, when he was confronted by the police, of course, he denied everything, and he simply made a promise to them that he would stay away from Miss Tarasoff. It raises the question whether or not Tatiana Tarasoff's life could have been saved if and only if the clinician made a decision to notify Tatiana and her family, which are the third parties in this matter, as well as the law enforcement personnel, of Mr. Padar's intent to kill her. Now, this, in fact, of course, made Tatiana's parents furious. They were very furious that they wanted to file a lawsuit against the University of California and the clinicians. The defendants, the clinicians in this matter, pleaded that therapists can't accurately predict whether or not their patient's actually going to resort to violence and carry out what they intend to do. Later, the court finally ruled that psychotherapists are obligated basically to protect the welfare of intended victims of the patient's conduct if and only if the conduct presents serious danger of violence. And it calls into question then what constitutes actual violence. Now, do you think that it would change the perspective or disposition of this case if Mr. Padar actually killed himself as well as Ms. Tarasoff after finding out that his psychotherapist breached confidentiality?
Justice Tom wrote the holding for the majority opinion that people outside the therapy should have protective privileges. However, Justice Mosk, wrote a partial dissent that this confidential information should only be released if there is actual intent of harm and not just because of subjective opinions. Ethics Code 401 is about maintaining confidentiality. A psychologist has a primary obligation and must take reasonable precautions in order to maintain confidential information about the patient. Dr. Moore did retain Podar's information up until the point that Podar told them that he had an intent to kill Tatiana, which would be seen as a risk. The issue that ensues is that Podar was left to terminate therapy without ever being committed, as the police did not see it fit that he be committed. And Dr. Moore did not warn Tatiana nor her parents about Podar's intent to kill, as Podar is left to be around campus and be around Tatiana with no repercussions. Maintaining confidentiality is mentioned again when Justice Clark dissented that part of the psychiatrist's reputation is to
discussing the limits of confidentiality, and that standard pretty much says that legal, institutional, or professional obligations frequently place limits on the extent to which private information acquired during psychological activities can be kept confidential. For example, mandated reporting of suspended child abuse or neglect, and that promising confidentiality without revealing its known limitations is a misrepresentation of the fact that may violate a person's privacy and liberty. In the Tarasoff case, the psychologist didn't discuss the limits of confidentiality with the patient. He did not inform the patient that if he was to say certain things like killing her, that not only would it be reported or that he couldn't keep that a secret, but the fact that he would also have to inform the family. In fact, in that case, they held the patient's confidentiality over the victim's even after he informed that he wanted to harm her. So when the case went to court, it was obviously turned down the first time because their argument was that they were protecting the patient's confidentiality first, and they didn't really understand their duty to warn.
In Standard 4.04, minimizing intrusions on privacy, only minimum necessary information of patients would be included in verbal and written reports and consultations. Psychologists should never discuss confidential information obtained in their work except when they are under certain rare circumstances, which I will discuss in the next ethics code. Disclosures of confidential information, if it's ever happened, it would have to be limited. For example, in the Tarasoff case, Dr. Moore, which was Podar's psychologist, had a supervisor named Dr. Powerson. So when Dr. Moore consulted with Dr. Powerson on the case, he would provide only the information pertinent to Podar's issues with Tatiana, not anything that's not related. Standard 4.05 disclosures states that Psychologists may disclose confidential information with an appropriate consent from clients or without the consent if it's mandated by law. But what's considered as mandated by law would be different from state to state. After what happened to Tatiana, Florida legislators added some exceptions to confidentiality. Even within the same state, like within Florida, exceptions to confidentialities differ from one mental health professionals to the other. We have one for psychiatrists, one for psychologists, and one for social workers and other mental health professionals, even if they're facing the same ethical dilemmas. So under Florida statutes 490.0147, when patients communicated to psychologists a specific threat to cause serious bodily injury or death to an identified or readily available person after making a clinical judgment that patients have the intent and ability to carry out such threat, psychologists will disclose the information to potential victim and law enforcement. There will not be any legal action or criminal or civil liability against the psychologist, and it is ethical to do so.
4.06 Consultations. When consulting with colleagues, psychologists should not disclose any information that could reasonably identify their client unless they have prior consent to do so. And they should not disclose any information unless it is pertinent to achieve the purpose of the consultation. A psychologist in the Tarasoff case chose to seek a consultation because he was concerned that his client would follow through on his death threats that he made to Tarasoff. This would be ethical as long as he did not reveal any confidential information that could lead to the identification of his client, or he received consent. In this case, it is unlikely that he would have received consent, so he would have to make sure that he only disclosed information that couldn't identify his client. And he would make sure that he only disclosed information that would be pertinent to the case. Standard 4.07. The use of confidential information for didactic or other purposes. Psychologists should not disclose any confidential information or personally identifying information in their writings, lectures, or other public media regarding their clients, patients, students, research participants, organizational clients, or any recipients of their confidential services, unless they have received written consent from the person or organization, they have taken steps to disguise the person or organization, or they have the legal authorization to do so. The Tarasoff case received a lot of media attention, but the psychologists in this case would be unethical if they shared any confidential information regarding his sessions with his client. For example, should the psychologist want to write a book about the Tarasoff case and his experience being involved in it, he could not include any confidential information from his sessions unless he received consent, or he took steps like taking out basically any information that would lead people to identify his client in this book. Or for another example, let's say he wanted to do a TED Talk. He couldn't use any confidential information from any of those sessions during his TED Talk. He would only be able to talk about the information that is public knowledge.